Welcome back, everyone. Today's case centers on a defendant already on deferred probation for abandoning or endangering a child, a serious offense with high stakes. And now, the court is reviewing whether she violated probation conditions again. Tension's already high, so stick around. This one gets emotional fast.
Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. That probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be safety, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request safety, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medical.
And here comes the list. Whenever a judge starts reading probation violations like it's a grocery receipt, it's usually not a good sign. Curfew violations, drinking, hunting for drugs, skipping mental health treatment. This is a pattern the court cannot ignore.
Medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the SAFE-P. What I'm asking the court to do is hold the SAFE-P in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay. Whether it be 14 days, whether it be 30 days, I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SAFE-P in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if SAFE-P is still in her actual best interest at this point. We understand that SAFE-P is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented.
This is actually a key legal strategy, shifting focus from willful violation to medical instability. If the court believes her relapse was caused by a medication change, it could justify treatment over punishment. The question is, will the judge see it that way?
Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, allow her to be placed in the inpatient.
But we don't, do we know, is it up to the hospital how long she stays?
I believe so, Your
can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to SafeP and now wants to do things on her terms. I think SafeP is where she needs to be based on the relapse and the violation she had. And I want to bring to the court's attention when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SafeP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SafeP.
SAFE is a state-run drug rehabilitation program, but with a structured, prison-like environment. It's not optional and not comfortable. The defense wants her in a private hospital instead, which is more flexible. The prosecution sees that as her avoiding accountability again.
If she has the right medication and she is of the right frame of mind.
The special needs SafeP facility, do they adjust medications and things like that?
Yes,
yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs SafeP. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChauce's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you, Mr. Ruiz, for being here as well.
This is where the history matters. She already had the chance to choose her own rehab program before, and it failed. So the prosecutor is saying, we've seen this movie already. And last time, it didn't end well.